right, good afternoon, everyone. Welcome again to the Lubar Center here at Marquette University Law School, Eckstein Hall. I'm Mike Goucher, and this is On the Issues. It's our continuing series of conversations with news and policymakers or people we say are doing interesting and important work in this region and beyond. Today, we're going to be talking about the U.S. Supreme Court. When we were putting this event together, I'll introduce you to our guests here in just a moment, but when we were putting this event together, we talked a little bit about what has happened on the court in the last say 14, 15 years. So you go from 1994 up until about 2005, and you had the same justices sitting on the court for that entire time. Then in about 2004, 2005, you start to see a turnover. So now a majority of the justices have turned over. So we have sort of a new group of justices. But one of the questions we had is, has that really changed much in terms of the way the court approaches its business and the terms of rulings it makes on individual rights cases or cases involving federal and state relations? Have things really changed? Well, today we're going to talk to two gentlemen who are experts on the U.S. Supreme Court, and let me introduce them to you. The gentleman seated to my immediate left is Ernest Young. He is the Alston and Byrd Professor of Law at Duke University. He is a scholar of federalism and a former law clerk to U.S. Supreme Court Justice David Souter. He is the principal author of Friends of the Court Briefs in several recent U.S. Supreme Court cases. And seated next to Professor Young is Professor David Strauss. He is the Gerald Ratner Distinguished Service Professor of Law at the University of Chicago. He is an editor of the Supreme Court Review. He has argued 19 cases before the U.S. Supreme Court, and he serves as faculty director of the University of Chicago's Jenner and Block Supreme Court and Appellate Clinic. Won't you please welcome Professor Strauss and Professor Young to Marquette Law School. We are delighted to have them here today. They're putting in double duty. Later this afternoon in our Bowdoin lecture, you'll be hearing from Professor Young. At least I hope some of you will be attending that, and then that'll be followed by some remarks from Professor Strauss. So we're delighted that you could take another hour out of your day to spend with us for On the Issues. We were just talking upstairs, and I said, you know, there's sort of an elephant in the room right now, and that's been the Brett Kavanaugh nomination. And what I don't want to do with these two gentlemen is to put them on the spot and say, what do you think about specific pieces of this nomination process? But what I do think might be helpful for all of us in this room is to talk a bit about the process and how it has changed, or has it changed, what we're seeing today. I'll let Professor Strauss begin with this one. What is your take on the Supreme Court nomination process, what we're seeing?
Well, thanks, Mike, and thank you all for coming to this event. I'm a little bit disturbed by the turn the confirmation process has taken, even in the last maybe 10, 15 years or so. And it's hard to pinpoint exactly what the cause is, or I'm sure there are many causes, but things have become a lot more partisan in a way that I think is really damaging to the court as an institution. I think at one time, there was a consensus among senators, at least senators on the Judiciary Committee, senators who are most centrally involved in the process, and really including the president and the people in the White House who were involved in deciding whom to nominate. There was a consensus that we really have to kind of make sure we take care of the court. And whatever happens, it should be someone who comes out of the process who will be respected and viewed as someone who can be a Supreme Court justice and not just a member of our team. And I think that's really eroded over time. I think the process has become much more of a partisan battle now. There was always that element to it. One shouldn't be naive about this and think, there was a time when partisanship had no role to play. That really would be naive. But I think it has taken a turn for the much more partisan. And what's really troubling about it is a lot of times, and I think this is one of those, once that happens, it's very hard to dig yourself out of that.
Mm-hmm. I was going to ask you one quick follow-up to that. I was struck by something. I saw Ruth Bader Ginsburg, one of the current justices, talking about what happened to her in 1993, and she said, this has become such a big show. She made these comments before the last couple of weeks, but she said, it has become such a big show now. I was confirmed by a 96-3 vote. 96-3. And she said, can you imagine that today? I was struck by that. Mm-hmm. It's very different than not all that long ago.
Right.
Well, it's not like it was rosy before that. I mean, there were the Bork hearings.
Absolutely.
For instance, and she was confirmed at a moment when there was a little more deference, I think. I do think the process has changed. I don't think the people being nominated have changed. There's not a different sort of people being nominated. I don't think the judges are more partisan who are being nominated. I think we've lost faith that a judge is all that different from a politician. I think if you look at the change in the reporting on the court from when Linda Greenhouse stepped down as a Supreme Court reporter for the New York Times to Adam Liptak, the first thing he did as the new Supreme Court reporter was to do a story on political science analysis of the court that purports to show that the court decides based on political grounds rather than on legal grounds. And I think that work, which frankly I don't think is very good political science, has become very well accepted in a lot of circles. And so the way we look at these people is different, even though the sort of person, the sort of credentials they have, the sort of temperament they have hasn't really changed all that much.
Is it damaging long-term?
I think it's very damaging. I think this way of treating the judiciary and treating the confirmation process is one of the ways the system can break down. People assume that the system won't break down if you follow the rules, right? But the fact is that the system incorporates all of these ways that the politics can go to hell and the government can become dysfunctional without breaking any of the rules, right? It used to be that you would never shut down the government even though the Constitution gives you the ability to do that, or you never try to cripple the executive branch by refusing to confirm any of their nominees, even though the Constitution gives the Senate the power to do that, or you never refuse to raise the debt limit or something like that, and use that sort of thing as a political weapon. There's all sorts of ways in which the Constitution confers these institutional points of leverage on various actors, but they used to be treated like nuclear weapons, right? They were there for deterrent purposes, but they were not the sort of thing that you would actually use. We're seeing those bombs go off now from time to time, and I think that basic sense of restraint, the basic sense that you would never go all the way to the mattresses in politics is a real loss.
Yeah, let me agree with Ernie on this, and I think it's a point that people lose sight of, not just people generally, but journalists and people also in our business of being law professors lose sight of, and it's a critical point, which is we think the Constitution, the document, what's written down, is our safeguard. Well, obviously what's written down is very important, but an awful lot of what protects us is not written down. As Ernie said, it's just understandings that you don't go to the limit, you don't play hardball. There are things that, yes, the document allows you to do, but you don't do it because that's no way to run a government. And I agree, those things which used to be taboos even and certainly norms are now getting eroded. And I think where it connects with what we're talking about on the court, you used to see justices appointed by a president of one administration, of one party, confirmed by a Senate controlled by a different party. That used to be pretty common. The justice that Ernie clerked for, David Souter, was confirmed 90-10 by a Senate controlled by the Democrats. Anthony Kennedy, who just retired, was confirmed, I think, unanimously by a Senate controlled by Democrats. Clarence Thomas was confirmed by a Senate controlled by Democrats. It was a narrow vote, but the Democrats did not filibuster, and he was confirmed. There are many justices I could name for you like that. Harry Blackmun, Warren Burger, William Rehnquist, very conservative justice as an associate justice confirmed by a Democratic Senate. I don't think we're going to see that again. I don't know when we're going to see that again. When President
What would have to change for it to happen?
Well, this is one of those things where you get into a cycle, and neither side wants to what they perceived as unilaterally disarm. President Obama nominated Merrick Garland, and precisely for this reason, he thought, I'll send up someone who is relatively old, in his 60s, which I don't think of as being relativly old, but
I'm right there with you.
But in Supreme Court Justice nominee world, unfortunately, that's relatively old. We're going to make Ernie be quiet about this. Relatively old, moderate, I mean, a Democratic nominee for sure, but relatively moderate. He'd been praised by many Republicans as a good person for a Democrat to appoint. Senator Hatch said, I think he's such a good nominee, I can't imagine President Obama nominating him. Well, President Obama nominated him. The Senate, controlled by Republicans, refused to go forward. I think now, if the Senate is controlled by Democrats, and a Republican president tries to nominate someone, you can imagine what Democrats will say. Are you kidding me? You're going to confirm a Republican nominee to their senators? And if the senators come back to them and say the kinds of things we were all just saying, for the good of the court, we need some bipartisanship here, the reaction from the Democrats will be, forget it. That's not what they showed us. Why should we show them? And once you get into that cycle, I don't know how you break out of it. And I'm afraid that's where we are now.
As a Republican, I feel some obligation to point out that I think the perception in the Senate on the Republican side was that Harry Reid had already endorsed hardball. He endorsed doing whatever you can, and that if the shoe were on the other foot, that there was no question what he would do. And so they went ahead and did it. And I don't know if that was a good judgment or not, but it shows, I think, the idea that we are in an age of hardball now. You do what you have the votes to do, whether or not that's going to undermine these sorts of norms. I do think there's one change that is not clearly bad, but that I think we've yet to see the full ramifications of, and that is that there used to be a norm of deference to the president's choice unless you could say that the person was just fundamentally unqualified or a bad person. Right? That you wouldn't just vote against them because you disagreed with their judicial philosophy or something like that. And I think the problem with that was that it compelled a focus on personality where you couldn't oppose the nominee without really smearing them in some sort of fundamental way. You had to go after their reputation, and you couldn't just say, I think they're too conservative for me, or I think they're too liberal for me. And I'm not sure that was healthy. I think that got us the Clarence Thomas situation, for instance. I think it might be healthier to be able to say, that person's too conservative for me. I'm not going to vote for them. The president, if the president wants to get this person, this Republican nominee, through a Democrat-controlled Senate, they're going to have to nominate somebody more moderate than that. Or they'll have to, they might even have to do something like promise to appoint, X number of Democrats along with X number of Republicans. So, this is the sort of thing that would particularly work on the lower courts. I'd rather we were having a debate about how conservative Brett Kavanaugh is and whether that's too conservative. I think that would be more honest. Instead, we've kind of had a reversion to the old politics, over the last week, and that's even nastier.
Is it possible? These are human beings. Is it possible to go through this process the way it currently looks and feels? And not have part of that affect you as a justice, that you can set aside all of what you experienced, all the things that were said about you, all the things that were suggested, that you can just set that aside and be impartial. You can be independent. Is it fair to expect our justices to be able to do that?
I think they can do that. I do think we underestimate how wounding the process is. Even in the instances, that seem to have gone pretty well. So, for instance, I had as a student the son of a Supreme Court justice who had gone through this process, and I thought the confirmation had gone. The vote was pretty lopsided. I thought it had gone reasonably well. That family was traumatized by that experience, and it was remarkable to hear them talk about it. And I don't think they were wrong. I can certainly see it from their perspective now in a way that I didn't see it before. But I think it is a profoundly unpleasant process for even in the instances that don't seem to go off the rails. Can they rise above that? Absolutely. I mean, judges are trained to abstract from their own experience in important ways, and I think they're pretty good at that. And I think in a way, they take refuge in that. I think there's a real comfort, in putting on the robe and thinking about a bunch of interesting legal puzzles and figuring out what the right answer is. That's probably the best therapy there is for it.
Do you agree with that?
Yeah. It's a great question, and that Mike asked about whether people can overcome the unpleasantness of the confirmation process. And from what I've seen, I agree with Ernie. I think even confirmation processes that seem to have gone okay, there was a little bit of unpleasantness, but really nothing that should have upset the nominee actually does upset the nominee and the nominee's family. As Ernie says, I think they absolutely should overcome it. I think it's actually unconscionable for them to hold a grudge against the side that opposed them. Whether they can as a psychological matter, I think in some cases probably not. The other part of this dynamic, which is part of the partisanship and also very troubling, if you think about what the nominee is doing, like right now, or starting when the person's first nominated, or sometimes even before that when they're thought about, they are talking to partisans. They are talking to people in the White House, in the White House counsel's office, partisan lawyers, but people who were very definitely on the team of the president, who were preparing them for the hearings. And increasingly now, this wasn't always the case, but increasingly now, the way they're preparing them is, we got our side, and the other side's going to try to get you. So here's how you help our side protect you, and here's how you fend off the other side and keep them from defeating your nomination. And they're immersed in this environment. This is their team. They'll even sometimes refer to it as their team, like my team might contact you for a letter. And that's, at this extremely stressful time, the time that their life's ambitions are on the line, their champions, their team, are partisans telling them, here's how you can win and defeat the other side. And I think the danger that even if they are conscientious, and as Ernie said, kind of, I'm a judge, I'm going to overcome this, and as he said, taking refuge in this, very hard for that, I think, not to mark them to some degree. And even if they didn't start out as being partisan, that experience, I think, can kind of make them burrow into one side in a way that whatever their intentions are, even with the best intentions in the world, it's going to be hard for them to overcome.
Let's talk a little bit about the current configuration of the court, and we're obviously waiting for whatever happens with the Kavanaugh nomination to happen. But how would you describe, and Ernie, I'll begin with you. How would you describe the composition of the court? I think people want to put labels on it, political labels oftentimes. They want to say it's a conservative court, it's a liberal court, so-and-so is a conservative, so-and-so is a liberal. How would you describe the court we've been looking at for not just the last couple of years, but the last 20 or 25 years?
I would call it a fairly balanced but leaning somewhat conservative court as we understand those issues at this moment in time. But if you look at the Roberts Court and what it has held over the past 5 to 10 years and compare it to what, for instance, the Warren Court, which is considered to be an extremely liberal court, was willing to do back in the 50s and 60s, it's kind of remarkable. So the Warren Court, for instance, was never willing to confront the president on questions of national security. They pretty much rolled over in most of those cases. Right? This court has blocked military commissions. It's intervened in various ways, even in national security cases. It's been willing to push back. The Warren Court never did a thing for gay rights, right? So, for instance, when they recognized a right to privacy, they said, well, of course, we're not saying, when we say that you can use contraception in your home, we're not going to do anything about sodomy laws. Those are clearly okay, right? There was never even an effort in that court. And this court has recognized a right to same-sex marriage. And even the dissenters in that case, I think, made clear that they were dissenting because they thought this should have been done through the legislative process, but that they were basically in sympathy with the goals of that movement. Whereas the decision in Bowers versus Hardwick a couple of decades before during the Berger Court had basically said, why are you people leaving in our court? You're an abomination, go away, right? And so the country has moved in critical ways. And so to say we have a conservative court now doesn't mean at all the same thing that it would have meant to have a conservative court in 1950 or 1970 or those times.
It's a very tough question, I think, to get a handle on. My inclination would be to say this court is really quite conservative, but I take the point that in some respects that you can identify, this court has done quote-unquote liberal things that past courts, even liberal courts, would not do. And Ernie's examples are good ones. I could give you the counter examples. This court eviscerated the Voting Rights Act. The Warren Court upheld the Voting Rights Act. This court was prepared to strike down 5 votes on one issue, barely upheld the Affordable Care Act. There's no question the Warren Court would have upheld the Affordable Care Act probably unanimously. The Berger Court even, considered a conservative court, held only by a 5-4 vote that it was constitutional to deny Medicaid funds to people seeking abortions. That was a very close decision. And the Berger Court, a conservative court, appointed by Richard Nixon, who had attacked the Warren Court and made appointments to try to undo the Warren Court's work. Nonetheless, in the Berger Court, that was a 5-4 decision. That claim would go nowhere today. The same Berger Court barely upheld the system of funding private public school education on the basis of property taxes, which was challenged on the ground that discriminated against poor districts. That was also a 5-4 decision. That also would go nowhere today, even though in a relatively conservative court that was 5-4. So it's very tough to get a handle on these things. The Warren Court was viewed at the time as extremely liberal, attacked for its liberal decisions. But if you think now about the Warren Court's decisions, which one would you overturn? You're not going to say school segregation is okay. Everybody accepts the Miranda warnings, even people who attacked it back then. There aren't that many people who think we should have sectarian teacher-led prayer in schools. One person, one vote, an intensely controversial decision, one with actually quite weak constitutional foundations. Who's going to attack one person, one vote now? So these things change, and things that were once seen as really, really liberal and extremely liberal become accepted. Ernie's talk this afternoon is going to be about a period, a very dark period in our history, when all three branches were aligned in defense of white supremacy, including the courts. Well, no one's defending white supremacy now, and well, that's probably spoke too soon. No responsible public official would get up and say, oh yeah, there's a superior race in this country, and it's the white race. That was common currency even among the good guys in the late 19th century. So things move, and it's very hard to get a footing on what counts as liberal and conservative. I would say, compared to public opinion, compared to even opinion in, say, legal elites, this court is really quite conservative. But I think you have to acknowledge that in the stream of history, it's very tough to get a footing on these questions.
I mean, one reason this is hard is that when we talk about conservative judges, we might mean one of two different things that aren't necessarily tied together. So there is a conservative position in terms of a certain substantive set of beliefs about, the role of government and the scope of individual rights and that sort of thing. But there's also conservative in the sense of just being resistant to change. On balance, you want to guard what you have rather than push boldly forward. And so I think any conservative court is going to have a strong element of the second thing. And so those Warren Court precedents, these justices were raised on those, especially the younger ones. We grew up watching cop shows in my generation where people were always read their rights. Mm-hmm. You can't imagine an arrest where somebody isn't read their rights. So why would somebody of my generation question Miranda? Of course, that's just the way the law works. And I think a lot of things like Brown versus Board of Education and the right to privacy in Griswold are just, they're so embedded into the social fabric now that even a pretty conservative justice is not going to want to contemplate the sort of change that uprooting that would entail.
Roe versus Wade, no matter how you feel about it, is ingrained in this country now. Do you think, David, I'll begin with you on this. Do you think that's something that could actually be looked at with a court that is 5-4 viewed as a more conservative court? Is that something that could be looked at?
Yeah, absolutely. I wouldn't. If I had to make a kind of prediction just for the sort of betting markets, I would predict that they will not ever write the sentence Roe versus Wade is hereby overruled. I don't think they will do that, but I do think they will systematically chip away at it and allow more and more and more and more restrictions. And so, in parts of the country where there is hostility to the right to an abortion, it'll be even more difficult than it is now to get an abortion. I think that's been a goal of the conservative legal movement for a couple of decades, and there now, I think, votes on the court to accomplish it.
You sure, Lee?
I agree with that. I think there's no way Chief Justice Roberts votes to overrule Roe versus Wade. If he wasn't willing to strike down the Affordable Care Act because he thought that would undermine the legitimacy of the court, even though at the time the Affordable Care Act approval ratings were south of 50%, I don't think he would be willing to run counter to not just Roe, but the reaffirmation of Roe in Casey, and especially the terms on which Casey reaffirmed Roe 20 years later, which the role of the court, the legitimacy of the court requires some constancy in our rulings. I think now somebody like Roberts is going to feel that in spades, and I suspect he would not be the only conservative that would join that position. Now, will they chip away in certain ways? Probably. I think that's right as well. But how you characterize that, I think, it depends to some degree on where you sit. So I think there's a lot of people who think Roe doesn't necessarily decide a number of subsidiary questions. And then there's people who think that Roe did decide certain limits on abortion as well. So, for instance, the partial birth decision, in which the court upheld restrictions on partial birth, was thought to be a chipping away. And yet, if you look at the reasoning of Roe, you could very reasonably come to the conclusion that, well, it's hard to draw the line, during pregnancy, but birth is birth, and is that chipping away to say that? So I think you will see a reopening of debate about how far the states can go in regulating abortion. I doubt that they will undermine the basic principle that Justice O'Connor espoused in Casey, which is that if you have regulations that are really not designed at regulating or limiting abortion in terms of protecting health and balancing the rights of the mother with the interest in the fetus, but with just discouraging people from exercising that right, I don't see the court going back on that principle.
Can I just add one
Yes,
to the discussion of Roe back to our earlier discussion about partisanship? I mean, Roe against Wade is a controversial decision, and there are many things to be said about it, and we needn't go into that here. But one thing that it was not was a partisan decision. It was not a partisan decision. There were 7 voting against Roe against Wade was 7-2. Of the 7, 5 of those people were appointed by Republican presidents. I'm cheating a little because one was Justice Brennan, who was a Democrat and famously liberal, although appointed by President Eisenhower. But the other 4 were Republicans. 3 of the 7, enough to switch the vote, were appointed by Richard Nixon, who had run against the liberal Warren Court and had 4 appointments early in his term. 3 of those 4 people were in the majority in Roe against Wade. Of the dissenters, there was 1 Republican, Justice Rehnquist, and 1 solid Democrat, Justice White, lifelong Democrat appointed by John Kennedy. So Roe against Wade at the time was the furthest thing from a partisan decision. And that sort of, exactly what has turned that into such a partisan issue is a very complicated question having to do with the way in which American politics has changed. But that's the change, that what used to be yes, controversial, yes, a subject for dispute along the lines Ernie described before. Is this a proper subject for the court to get involved in? Does this involve individual rights that the court should protect? Are we adhering to precedent? Instead of those disputes, it's now, are you red or blue? And that's been a real change, and that's not good.
My understanding was that the nonpartisan nature of the decision on the court reflected the nonpartisan character of opinion about abortion in the country at large at the time. It was not a Democrat-liberal issue. It wasn't even a liberal-conservative issue. And what polarization means to the political scientists is that our ideological divisions have come to align with our partisan attachments and everything, and become more coherent, right? It used to be that there were liberal and conservative Democrats and liberal and conservative Republicans. Now there aren't, right? Our ideology and our partisanship align. And I think a further aspect of that is that issues like abortion, people have finally sorted
for themselves
into an ideological position.
Ernie, you mentioned, you were talking about Chief Justice Roberts, and I wanted to spend just a couple of moments on him. What role do you see him playing as we move forward? I think you said to me that you could see him being more of a Kennedy-esque figure on the court. In what sense?
I think he deeply cares about the legitimacy of the court and the role of the court, and I think he sees being Chief Justice as a different job from being a regular justice. I think he thinks he has a unique obligation to care for the overall legitimacy of the institution, apart from what he would do if he were just sitting in one of the other chairs. And you see this I played a bit part in a PBS documentary on the Supreme Court, and Chief Justice Roberts played a much bigger part. And just the relish with which he talked about John Marshall and the role of the court and the legitimacy of the court and the importance of that over time was so apparent. And so it shouldn't surprise anyone what he did in the healthcare case. And it shouldn't surprise anyone if he votes to reaffirm Roe versus Wade someday, because I think he thinks he's got the institutional role of the court first. Now, is he a very conservative jurist? Does he hold pretty conservative views? And does he sometimes act on those, of course, but I think there's always the two sets of considerations, which other justices also care about legitimacy, but maybe don't feel quite the same institutional obligation.
What's your take on the Chief Justice?
I don't really I don't disagree with any of that. I think he's very much aware this is the Roberts Court and will be known in history as the Roberts Court. I think he said at one point in his confirmation process that of the 100+ people who've been appointed to the Supreme Court, or maybe he was saying about the Chief Justices, most of them were failures. And he doesn't want to be a failure. So I agree with Ernie, both points of what Ernie said, that I think he very much cares about the court as an institution. I think he takes it very personally, but also that he is really quite a conservative person in his orientation. He's not in any sense a centrist in his political judicial orientation. He's quite conservative.
I want to spend a little bit of time on something that you have experienced firsthand and you know to have changed. And we mentioned, as we were introducing David, that you've been before the Supreme Court on 19 different occasions. Your first occasion was 1981?
81, yes, which brands me. I know. I was young then.
Well, tell us, that was an interesting day for you and for the court.
It was the first Monday in October. Needless to say, I remember my first argument in the Supreme Court. It was the first Monday in October, the day it's by statute when the court begins its sittings, and it was the first Monday in October, as well as the name of a not very good movie. And it was also Justice O'Connor's first day on the bench. She was the first woman appointed to the Supreme Court. This was her first day. And as a point of pride with me, that I gave her her first straight answer to a question she asked, because it was the third argument of the day. She had asked the question in one of the earlier arguments, and you have to remember, no woman's voice had ever asked a question in the Supreme Court courtroom before, ever. She asked the question, the lawyer talked over her. Never, just kept going. And I was a 20-something kid in the Solicitor General's office, drilled to my ears on how you treat the justices. So I hope I wouldn't have done it anyway. But she asked me whatever question she asked me, and I gave her an answer. If you argued before Justice O'Connor, you would have noticed that later in her career, she really, I mean, none of them likes it when you don't give them an answer to their question. But she really didn't like it. I don't know if you saw this when you were clerking. She really didn't like it if you didn't give her an answer to the question. If you deflected it, said, well, that's not this case, to a hypothetical question. Yes, counsel, it's a hypothetical question. I know it's not this case. Answer my question, please. She was very, very tough on that issue, but that was my experience. The case was a totally nondescript case about some statute Congress repealed a couple of years later, so we don't have to go into
The justices, to follow up on that, though, the justices are now much more aggressive in their questioning, are they not?
Yes, the court that I argued before when I was in the government and Solicitor General's office, which was the job I held starting in '81, were much more passive, and you could often get through quite a bit of your argument without getting asked questions. Justice Stevens, who was wonderful in all respects, usually would wait for someone else to ask a question. And then he'd say, now that you're interrupted, may I ask? He was a great questioner, very incisive, very sharp, but it was that sort of tone that will sort of, we won't kind of badger you. The court since then has gotten, as Mike suggested, much more aggressive, and it's not particularly, I mean, it happened to me once or twice too in the olden days, but that sometimes you don't even get to begin your argument. Sometimes even before you say the traditional Mr. Chief Justice, and may it please the court, you get a question. And you certainly don't, it's rare to be able to get up there and orate. They're asking you questions at a fast clip. I don't think that's a bad thing. I think it's a good thing that they're engaged and on top of things. Sometimes the questioning, you kind of wonder, are you really interested in what I have to say, or are you interested in like scoring points with your colleagues on the bench and you're kind of using me as a backboard to fling a pass off, hoping it hits someone else up there. So there's a little of that, and as an advocate, you have to figure out how to manage that. But there is a level of engagement now that you did not see a couple decades ago.
Mm-hmm.
One thing we try to teach our students when they're doing moot court and preparing for that sort of thing is they come in with this idea thinking that if I get through my argument and I get to say my spiel that I've come up with and it sounds good and I don't get knocked off it by these questions, then I've done what I was there to do. And we try to tell them that if you deflect the questions so that you can finish your spiel, you've failed. Right? Because the questions are the only insight you are going to get into what worries these judges about your case. Right? They may or may not be interested in your spiel, but you need to listen to their questions because that's where you're going to lose. If you're going to lose, they're telling you, what is bothering me about what you're saying is this, how would you respond? That is golden, right? And so I think it's great that the justices are asking questions. They may have got, the feeding frenzy may have gotten to the point of diminishing returns, I don't know. I think that's why Justice Thomas doesn't ask that many questions. I think he thinks there's enough questions being asked, but plus the one time I ever saw him ask a question when I was clerking, he didn't get a straight answer from Larry Wallace, and so I think he just gave up.
Not getting a straight answer. I won't go there. I do want to sort of, I'm sorry, it's just the second one thing about that one great thing about oral argument before any court, I think, is it's not that often that you get to go face to face with a person who's going to make an important decision and actually look them in the eye and try to persuade them to do what you want them to do. That's you don't get to do that with the president. You seldom get to do that unless you're a staffer with a senator, but as just a person representing a client, that's a sort of an experience or a relish. And, then you're at the Supreme Court, you can actually look them, it's an intimate courtroom. You can actually look at them and they ask you, as Ernie said, they ask you a question and okay, if they're asking that, that's what I need to speak to. Whatever I came up here planning to speak to, I need to speak to what's bothering them. And if you're well prepared, you have an answer and you give them the answer and you look at them and sometimes you think you persuaded them, and sometimes you look at them and you think, no, I haven't persuaded you, have I? No, that was my best shot. You don't say that. But you know that you're not going to get that vote.
I'm curious, what was Justice Souter, as you clerked for Justice Souter, what was his approach to questioning? How valuable did he view it?
I think he thought it was pretty valuable. Occasionally, he had been, a public lawyer in New Hampshire in the Attorney General's office, and so he tried criminal cases, and occasionally he would slip into prosecutor mode, and he'd lean forward, his face would turn kind of red, and he'd just start cross-examining these poor people, and we'd be in the cheap seats, watching it, and we'd just sit back and say, oh no, this is not going to go well. You poor man.
I have to ask you about something we discussed on the phone the other day, and yeah, it was, I thought, a really interesting comment about the kinds of cases that you've argued before the court, and that there was something particularly rewarding about a case that was lower profile, that the justices may not have known nearly as much, may not have been seen to have sort of staked out a position on that, something that was low profile. Why was that so rewarding as opposed to the higher profile cases?
Yeah. When I was in the government, I was a kid, and especially in my early years, they gave me cases that were dogs, which is to say, as Mike said, low-profile cases. I guarantee you've never heard of any of them, and if I tried to tell you the issue, you would fall asleep within the first 10 seconds of my description of the issue. But it's a Supreme Court case, and something important is going to hinge on this, even if it's an obscure issue. And as Mike said, those cases, in a lot of ways, are the rewarding ones to argue because the justices don't know what they think. They've never thought about this issue before. This is the first time they've encountered it. Is in your case. They don't have predispositions. It's not ideologically charged. It's not something that appeals to them as liberals or conservatives or whatever. And you can really kind of try to persuade them that your side is right, and they honestly don't know. And that was very rewarding, as opposed to an issue like abortion, affirmative action, capital punishment, or even some of the criminal justice issues that they get a lot. They know what they think. And unless there's some technical wrinkle in a case, you're not going to persuade someone to change his or her mind on an issue like that. And so that becomes much more of a slugging match than these really superficially, at least, boring cases that take up a significant part of the court's docket.
You mentioned that in 1981, you were there when Justice O'Connor had her first day on the job, and I think a question that I'd like to talk about for just a moment or two is that the court has changed. It is a more diverse court. than it was in 1981. Does that matter? Does it make a difference? Do we see it making a difference in rulings, in case law? What can you tell us about that?
I think it matters. For instance, there's a lot of criticism, in academia and out in the media of Justice Thomas that he's, even though he's African American, his views aren't right for African Americans, or he's not the right kind. And so I think even in his case, though, even taking on board that viewpoint, you still see a sense of what it means to be black in America in some of these cases. There's a famous case about burning cross in a free speech case, and Justice Thomas writes separately to say, this is what this means. This is what it is like to experience this, and this should inform our judgments about it. And I think it's a unique perspective. It's an incredibly valuable perspective. And I think all the justices have different experiences that they bring to it. I know when Justice Souter was nominated, people thought, this is a middle-aged white man from New Hampshire who's kicking and screaming to be dragged outside the borders of the state, who doesn't have a broad life experience. I do think we underestimate the ability of the justices to kind of take on board perspectives that you might not think their life experience would give them access to. He was able to empathize and put himself in the shoes of people you never would have dreamed. He was even able to understand a computer copyright issue when he'd never used a computer or had any idea how they worked. And so the justices are quick studies and they're able to project, but I think it is valuable that they have these diverse perspectives.
David?
Yeah, I agree with that, and really, how could it not matter that something that is central to who you are would affect both your judgment and, as Ernie said, the conversations you have with your colleagues. Justice O'Connor wrote somewhere as a tribute to Justice Thurgood Marshall, the first African American appointed to the Supreme Court, how much of a difference he made in conference when something would come up, and Justice Marshall, who had spent many years litigating cases on behalf of African American criminal defendants in the Jim Crow South, was able to say, let me tell you how what is actually going on out there, and that made a difference. The other sort of story I'll tell, it's about one of Ernie's sometimes colleagues who was a great Supreme Court advocate. And this instance kind of tested his, I'm not going to say his name, it tested his skill. Justice O'Connor and Justice Ginsburg were the two women on the court at the time this argument took place. They were the first two women appointed. And he got a question from one of them, I think got a question from Justice O'Connor, and he began his answer by saying, yes, I agree with that, Justice Ginsburg. And she pointed out to him that that was the other one, that she was Justice O'Connor. So this is obviously a supremely awkward moment. So here's what he did. The next question he got, I think, was from Justice Kennedy. And he said, well, here's how I'll answer that, Justice Souter. Which is, I thought,
did it work?
Great. Yeah, great. Well, how could you do better in that situation? But it is emblematic. In fact, someone recently, I forget in what argument this happened, but it happened relatively recently, last year or so, called, I think, Justice Ginsburg by a different woman justice's name. And she just said, well, that hasn't happened in a long time.
My favorite comedy movie is Roxanne, which is a Steve Martin retelling of the Cyrano de Bergerac story. And Steve Martin's character has this nose that goes out to here, and everyone around him is afraid to mention it. And you're not ever supposed to look at it. You're not supposed to mention it. And the new guy comes in, and he's warned about all this. But because he's been warned about it, because he's dreading this so much, you can't help but think about it. You can't help but look at it. And I think the confusing Justice O'Connor and Justice Ginsburg or now Sotomayor has become such a thing of dread to Supreme Court advocates that they're more likely to do it because they're trying so hard not to.
Maybe my final question, we'll take a few questions from the audience here. My final question deals with for lack of a better way of putting it, the celebrity that now goes with being a U.S. Supreme Court justice. That's my characterization. It may not be yours. But my point being that we see justices sitting down for interviews now. We see movies made about justices. Ruth Bader Ginsburg, very successful documentary film out about her. It seems to me that the justices have a considerably higher profile today than they once did. I may be wrong about that. I'd be curious to hear what the two of you think about that. Is that a good thing, to hear more from the justices, to see more of them in different media venues?
So I clerked for the Recluse, right? And during my tenure as a clerk, there was a poll where I think it was the Post, had gone around and surveyed people about how many people recognized each justice. And there was a clear winner as the justices perceived it, and that was Justice Stevens, who came in at 3% recognized him. So he was just, yes, this is how we want it. Souter was at 4%. Justice O'Connor was the worst loser because she was so historic. She was well over 50%. And so I think they really crave anonymity, at least my guy did. And I thought that was good. I think Justice Ginsburg has gotten herself in a little trouble being, you shouldn't tell reporters which decisions you plan to overrule if your candidate wins the next election, for instance. And that can be, I think that can undermine the court. On the other hand, I'm a little conflicted because I do think the Supreme Court comes closer to being what it should be than any other institution in American public life. And the more people know about it, the more people understood what these justices are like, 1 to 9, left to right, how smart they are, how dedicated they are, how hard they're trying to be principled. I think that would really, just bolster our credibility not only in the court, but in our belief in American government not being completely dysfunctional. So it's hard to be against people knowing more about Supreme Court justices. I think they are, without exception, admirable people.
Yeah, I'm going to agree with that. I'm also kind of troubled by the culture of celebrity has kind of taken over everything. And so it's in a way not surprising it would take over the Supreme Court too, and that they would get bids for their attention and be tempted by them and be tempted to be celebrities. I mean, that in a way is kind of inevitable. And it makes me very uneasy too. Having said that, I do want to agree with Ernie that despite my reservations about the current court or the court that is likely to be, and I have a lot of reservations about it, day to day, they do their jobs carefully and well. In lots of these cases that we don't hear about, that aren't on the front page of the newspaper, they take their work seriously, they get prepared, they ask good questions, they write good opinions, and really in a lot of ways, I don't want to cast aspersions on the other branches, but I guess I'm going to cast aspersions on the other branches. Do their job very well. I do think there are layers of the bureaucracy in both the executive branch and the legislative branch that also do their work very well. And in a way, you could see the justices at their best as just being really, really good bureaucrats. I have this problem, I have this law, I'm going to solve the problem in a way that makes the most sense. And it would be a good thing if people knew more about that.
Would cameras in the courts? Would cameras in the Supreme Court?
Your former boss would just love that, wouldn't he?
He always said it'll roll over my dead body. And one thing people don't know about that is that the New Hampshire Supreme Court, where he had, this was his previous gig, had cameras. And so he was the only justice at that particular time that had actually been on a court that had cameras and seen the effects that they had. And he would say that he caught his fellow justices grandstanding to the cameras. He caught himself grandstanding to the cameras, and he just thought that was a terrible influence. But on the other hand, I do think it would be better for the country if people knew more about the Supreme Court, because I think it's inspiring.
Mm-hmm. Briefly, any thought on that?
I'm ambivalent about it. I agree it would be good to see how oral argument really is serious intellectual exchange, not sort of pyrotechnics. I think they're human, and the temptation to grandstand would be there. That's right.
Let's take a few questions from the audience. If you're in the seating bowl, press down on the black switch in front of you so we can all hear your question. Ryan will also try to help with that. If you're in the area seated in the back, just raise your hand and Ryan will bring a microphone over to you and we'll take a question. Again, no speeches and just questions and it'll all be good. Let me begin right here. Yes.
Could you comment on what is the advantage to our justices being put in a position that it's a lifetime appointment as opposed to other democracies that don't do lifetime appointments?
I'm a conservative. I think change is to be presumed against. Right? If it ain't broke, don't fix it. That's the kind of conservative I am. And so I'm just not sure that aspect of the court is broke. I mean, there are problems that you can identify with it. Can you imagine a better system? I'm coming around to the view that I get more respect for the arguments against life tenure than I used to. Certainly the more regular timing for new appointments would be an advantage. On the other hand, I don't think we necessarily know what the unintended consequences would be, and I think the court is functioning well. I would do a lot of reforms to Congress and the executive before I got around to monkeying with the way that the court works.
I share some of the instincts, but I think life tenure is not a good thing. I would have fixed non-renewable terms of some substantial lengths, 14 years, 18 years, something like that. I think one issue that Ernie adverted to is sort of the luck of the draw about who gets to make appointments. Justice has to retire or die on your watch, otherwise you don't get to make an appointment. They time their retirement sometimes to be appointed by a congenial president, which, how could you tell them not to, but should they be doing that? There's an incentive to appoint people who are very young. Then why? That can't be a good thing. The other thing I have to say, I think they are all great. I think some of the oldest justices are making fantastic contributions. But if you look at the age distribution on the court, if you saw that age distribution on a cabinet, you would think, oh, that's some Soviet cabinet where they all are octogenarians, and that's not working very well. No board of directors of a major corporation would have that kind of age distribution. So, even though I think these particular people, nothing against them, I think the older justices are, doing every bit as great a job as everyone else. It's not a healthy thing. So despite, I think Ernie's right. Could a law of unintended consequences could kick in here, but I think that it's not going to happen because it takes a constitutional amendment. There's a little sort of cottage industry of scholars who say not, but it would take a constitutional amendment. But I think it would be a good thing.
I'm going to look to the back to make sure I'm not missing anybody back there. I'm going to go over to this guy right here. Hang on a second, we'll bring you a microphone.
Thank you. So it used to be the case that there were a number of justices who had elected political experience, like former President Taft and Earl Warren. But now I think there's no one on the court that has any elected experience. Do you think it would be a good thing if there was somebody with that sort of perspective on the court?
So when I was clerking for the question is whether we should be appointing more people with elected political experience. Hugo Black was a senator before he was a justice. When I was clerking for the First Circuit, it was during the time when Breyer was appointed, and the conventional wisdom was that Clinton's first choice had been George Mitchell, who had been an elected official, and that he wanted him because he'd be a good politician on the court. He'd be good at assembling, winning coalitions and things like that. And Mitchell said no, apparently, and so his second choice was Stephen Breyer. And the irony of that, I always thought, was that Breyer was almost certainly a better judicial politician than Mitchell ever would have been, right? So the reason he was looking for an elected official that would be more good at politicking the other justices, I don't think, it doesn't work the same way on a court. There are politics, but they're different politics, and Breyer is extremely skilled at it. I don't think Mitchell would have been necessarily that good. It's hard to think of that many, isn't it, that have been really successful justices who were
politicians. Justice
there are
O'Connor
some.
was
Yes.
maybe an example.
Yes.
Other questions? Go over here. Go ahead.
I had the opportunity to know Chief Justice Douglas. You're too young to remember him, but he came here and went for a hike through the Kettle Moraine with my husband and many of us, and Rehnquist, who lived in the block behind me. Their philosophies and their rulings on the court were so different. Douglas wanted to protect the environment for common good. Rehnquist did so many things that destroyed the environment for the common good. How can you justify those two extreme differences when the justices are supposed to interpret, not be a Republican or a Democrat or whatever? I don't understand that.
You keep turning to me for the hard one.
I think that's a coincidence.
I think that Supreme Court decision comes down, and the newspapers say the court voted for the environment or against the environment, right? But typically, the actual question is so much more narrow, much more marginal. Was an environmental impact statement required before this particular project? Or does this particular sort of entity or of plaintiff have standing to seek an environmental impact statement in challenging a particular project or something like that? So I think that it might be that their personal philosophies were very far apart. But to say that, Douglas saved the environment or Rehnquist destroyed it, well, but I think the question is, at the margin, how much difference did those make, right? I mean, how big a legal change did those particular rulings take? And that, I think the impact of these cases is often much, much more narrow than that. I think, for instance, all 9 justices share a basic commitment to the central goals of the Clean Air Act and the Clean Water Act. That's part of our, fabric now. They differ about much more, questions at the margin. There are difficult questions in the interstices of those statutes about, how far they go. But I think we do the court a disservice when we put it in such stark terms, I guess.
Can I ask a quick question and follow up on that? How much do the views of justices evolve over time? Do their philosophies change with time? Are there numerous examples of that, or are they pretty consistent in the way they approach cases?
You're doing it again.
Do that?
You go ahead.
You have a view.
People think Souter evolved. Right? But if you paid attention to what he said at his confirmation hearing, everything that happened afterwards, I think, should not have come as a surprise to you. They asked him, who is your favorite justice? He had said John Marshall Harlan the Younger. What do you like about him? Well, I like his opinion in Poe versus Ullman, right, which was a privacy case from the Warren Court that offers the best articulation of the right to privacy. And then when Casey comes down, reaffirming Roe versus Wade, they have huge block quotes from Poe versus Ullman, right? Surprise, surprise. Well, not if you were paying attention. I think that what changes more often than the justices' views is the issue sets coming to the court change. So FDR appointed 4 justices, Black, Jackson, Frankfurter, and Douglas, right off the bat, and he appointed them for the avowed purpose of upholding the New Deal. Because the old court had been opposing the New Deal. He wanted justices that would uphold the administrative state, uphold very broad views of federal power. And those justices absolutely did what they were put there to do, right? But then, 20 years later, they're all still there. But now the issues are the scope of individual rights, the rights of the accused, the rights of free speech, rights of privacy. And it turns out those justices have very different views on those sorts of things. Right? So did they evolve? No, it's just that the issue set has changed and revealed differences that you didn't realize were there because you were thinking about something else when you confirmed them.
I'll give you the final word.
Yeah, I agree with that a lot of what seems to be evolution is in fact the issues changing. Another example is one I mentioned before, which is abortion. Nixon ran a political campaign in 1968 that was focused, a lot of the focus is on the Warren Court. Now, the Warren Court was too favorable to criminal defendants, and he was going to restore law and order. And he got 4 appointments, a lot, early in his term, appointed 4 justices. And on criminal procedure issues, they pretty much did what he wanted them to do. But he wasn't thinking about abortion. And so when abortion became the salient issue, Harry Blackmun, one of his appointments, became identified as a super liberal justice, having been appointed by this conservative president who ran against a liberal court. And what looks like a change is, in fact, a new issue emerging.
I am going to be respectful of everyone's time. We started a little bit later today, just to make sure our guests could be here comfortably. I want to say thank you to everybody who attended today. We really appreciate your interest, and thanks for your good questions. And most of all, I want to thank our guests who are back for a return engagement later this afternoon with the Bowdoin Lecture. I want to thank Professor Young and Professor Strauss for your excellent insights and perspective.
Thank you.
Thank you.
Good to have you.
Thanks for coming.
Thank you.